Virginia.
Yes, ma'am.
All right, thank you. You can have a seat. This is cause numbers 25 DCCR 0838 0839, and then there's 21 37809. And you guys are just gonna have to bear with me. I woke up with this, so I didn't smoke 12 packs of cigarettes. I just sound like I did. All right. Mr. Fletcher was previously in court, entered pleas of not true in a motion to revoke probation in the 21 cause number on probation in that case for the second degree felony offense of possession of a controlled substance. And the allegations, give me just a second. There. Okay. Counts 1 through 5 were all pleas of not true. And then I'm just going to try to look back. Were there any pleas of true to any counts, or was that all of the counts in the motion? Is what I'm looking at. Does anybody know? Do y'all recall?
He pled true to any of the counts.
It was,
That's right.
those are the only, there were 5 counts.
Yes, Judge.
I'm gonna double check that too. And so we've got count 1 was the new offense of manslaughter. Count 2, offense of criminally negligent homicide. Count 3 was aggravated assault with a deadly weapon. Count 4, possession of marijuana. And then count 5 was unlawful carrying a weapon. And all of those, well, not all of them. We've got the first 3 stem from the same date of September 18th of 2024. And then counts 4 and 5 are from July 4th of 2023. And so we're set for a hearing today on the motion. And then once we get through this motion and do today, we'll figure out what to do with the new offenses. But we're going to go on that motion first. I've gotten the updated report from probation. Have you both had an opportunity to review that report?
I have a copy of the update.
It should have been emailed to you, but I can
Stay at the college. Oh, it sure was. On 1/6, is that what you open? Oh, that's a Johnny's report. I don't have an updated report.
it was some time ago. It looks like the day of the report was actually October 24th of 2025.
Yeah. November 24th. Looks like November 24th.
Date of sentencing was supposed to be November 24th. We were set initially then and then reset it for a special hearing to today, so for witnesses.
I'm sorry.
You're good.
I
So
don't think I got that.
okay.
First.
It's, can you just come make a copy of mine if you can't find it, please? Okay, thanks. I'll let you take a look at mine, and Miss Warner's gonna bring one for you. And there's a letter attached also that was I've made part of it. How about that? You found it? Yeah.
Is that the rest of yours?
Mhm.
It's going to be from the very back. That's us. Not sure.
Mr. Guards, there it is.
Either we have a change of lawyer at some point.
Maybe so. I think that could be it as well.
I'm sorry.
No, it's totally fine. I'm just not seeing it. So here we.
Okay. Yeah, it's short. I don't think there's anything It's yours.
Oh,
All right, and so is state ready to proceed?
State's ready, Judge.
Defense ready?
I can be ready. Obviously, I have an objection, shockingly. I want to object at this time, Judge, to a couple of things. One is, I anticipate the state is going to essentially put on a miniature trial for these, alleged new offenses that he currently has a trial setting for, is my understanding. And we, essentially by doing it this way, the state is accomplishing two goals that we object to. And one is, converting him into a convicted felon for the purposes, arguably converting him into a convicted felon for the purposes of an actual trial for which he is presumed innocent. And we want our day in court with a jury. And then secondly, Judge, I object to the nature of how the state has pled this as both a manslaughter and a negligent homicide, because and then an aggravated assault. All three essentially, what this is a car accident case involving a death, certainly, but the way that it is formulated here, it makes it appear that there's multiple deaths for starters, and second, again, our concern, our objection is that we believe those types of offenses, is particularly in this case where there's not an aggravating factor of intoxication or something else about these offenses, that ought to be properly placed in front of a jury. And no offense to this court, obviously I have great relationship and trust in this court, but for his purposes and for his rights, we believe that this ought to properly, those offenses anyway, ought to properly be in front of a jury. And so we're asking for that. That's what I was hired to do, is to present this case to a jury or defend this case in front of a jury. And so we object to the nature of the proceeding here with this type of offense.
So let me just, before Mr. Coleman, there's nothing legally that prevents us from doing it this way. We've obviously, some cases we do this way, some cases we allow the cases to go to trial first and then the motion. So
Not saying it's a perfect objection, Judge.
okay, I just want to make sure there's no legal prohibition from doing it this way.
I mean, I'm concerned about, again, obviously, if we went to a jury, Mr. Coleman would be welcome to ask for a lesser included of negligent homicide from the manslaughter indictment, et cetera.
So the indictments, I don't disagree that the indictments that have been handed down by the grand jury are for an aggravated assault with a deadly weapon and a manslaughter. There is not an indictment for a criminally negligent homicide. I can and have in a motion and a hearing found true a lesser offense. But what I don't think would be fair is for me to be asked to find true both of those offenses, making it look like there were two separate offenses. And so we can handle that a couple of different ways, but it would look like if I were to find count one and count two, I think they're count one and count two, sorry. Yeah, count one and count two are in essence the same offense, just one a lesser offense of the other. So I don't think that's fair and would agree with that. But what I can do, I guess, is if in fact I find either of them true, it would only be one. And then the other I would find not true if I found one true at all. Does that make sense?
Yes, Judge.
Okay.
Understood.
Okay. So wouldn't want argument, obviously, that they're both true. The aggravated assault with a deadly weapon, is that a different complaining witness?
Yeah, perfect.
Okay, so that makes sense to have the separate one to me.
Yes, Judge.
Okay.
The other component is, Judge, in the indictment, again, this is part of the stickiness of doing it this way. What the state has alleged in their motion to revoke probation is essentially that he committed this offense of manslaughter, of negligent homicide, and of aggravated assault. Problem is, under the statute 21.15, the state is required to prove with specificity or plead with specificity what it is the nature of the recklessness or the nature of the negligence. And it's my position that certainly the motion to revoke probation does not plead those things with specificity. And so it just makes the conclusory statement. Again, this isn't a possession of cocaine case or something where it's just obvious that what the elements are here. There 21.15 requires proper notice of what the nature of the recklessness and or negligence is in any reckless or negligence case. And that's not done here.
Well, the indictment reads, did then and there recklessly cause the death of an individual in the manslaughter one. And then it goes forward to say by operating a motor vehicle, driving 72 miles per hour in a 30-mile-per-hour zone in a residential area at night, and by striking the vehicle. Is that not?
In the indictment, it does, but we're not pleading to the indictment here. I'm not trying, again, I'm not trying to be overly difficult. I'm just being my normal difficult self. But to me, it's a problem because the motion to revoke probation that he's pleading to doesn't plead those elements with specificity.
So based on what I would say, based on obviously the nature of what the indictments allege, the level of proof obviously isn't the same, but I would anticipate and expect if I'm to find anything true, that the elements, every element of the offense as alleged in the indictment is proven by preponderance of the evidence, not just some random, the elements are the elements. I'm assuming that's what the testimony is going to be.
And on that, Judge, Your Honor, I agree. The elements are the elements. What I don't want to be is hamstrung or tied to the indictment in a motion to revoke probation.
Well, I think it's only fair that the elements of, the motion alleges manslaughter. So it's just, the law says manslaughter is, and in this case, the indictment says it's what it is. And so you're going to prove what the facts of this case are, you would allegedly. So there's no.
I just want to get out in front of any technical argument that Mr. Gertz may make about at the end of the conclusion of the presentation of the evidence and the motion to revoke probation context, that for whatever technical reason, we didn't prove up something alleged in the indictment. That's kind of what I'm trying to head off.
So it's obviously a relaxed standard, but I don't see how anyone who's going to come, law enforcement especially, or whatever the allegation is what the allegation is. So I would expect that the allegation, pretty much as alleged in the indictment, is what the facts would be. It's just a different level of proof. Okay, does that make sense?
So then just to be clear, and again, I don't think he has to prove each of the manner and means of recklessness. I'm just complaining about the notice in the motion to revoke probation. So the
Okay,
state
but
is,
you have the indictments, and so you know what the notice is. There's no surprise here.
I just making sure
Yeah.
that's what he's relying on. Okay, thank you.
Okay. All right, anything else before we get started?
Not from the state. Your Honor, before we begin, I just asked the court to take judicial notice of the entire file, including the conditions of court.
Any objection to that? I'll take judicial notice of the court's file.
Thank you.
Thank you. All right, then any type of opening, Mr. Coleman, you may call your first witness.
No opening. State waives its opening at this time. The state calls Miranda Beza.
Good morning, ma'am. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may have a seat. And if you'll just pull that microphone down, make sure you speak loudly and clearly so we can all hear you, okay?
Yes.
Thank you. May proceed.
Thank you, Your Honor. Would you please state your full name and bullet order?
Miranda Baeza
Baeza, I'll try to pronounce it correctly. How are you employed, Ms. Baeza?
with the Jefferson County Adult Probation Office.
Does part of your duties include supervising individuals who are placed on felony probation?
Correct.
And did you have or have you had an occasion to supervise an individual by the name of Larry Glenn Fletcher Jr.?
Yes, sir.
Do you see Larry Glenn Fletcher Jr. in the courtroom here today?
Yes, sir.
Could you please point to him and identify him by the article of clothing that he's wearing?
He is to my right in the tan clothing.
All right, as if the record reflected, the witnesses identified the defendant.
The record will so reflect.
And just for technical reasons, do you have a date of birth listed for him in your records?
I do.
What is that date of birth?
December 12th, 1992.
He's on a second degree felony probation for what offense?
Possession of a controlled substance.
And what is the length of that probation?
5 years.
And when did he go on that probation?
He was granted probation October 11th of 2021.
Now, you have not been his probation officer for the entire length of his supervision, have you?
Correct.
When did you start supervising this defendant?
March of 2024.
Now, you are, however, familiar with the process of explaining the conditions of probation to each and every probationer, correct?
Correct.
Do you have any reason to believe that that process was not followed with this defendant?
I do not.
Do you have any reason to believe that he did not acknowledge those conditions of probation?
I do not.
Do you have any reason to believe that he did not understand those conditions of probation?
I do not.
And final question is, what is condition number 1 of his probation?
Do not commit any new offense.
And let's be a little bit more specific. Any offense against the laws of the state of Texas or any other state or United States, is that correct?
Correct.
I'll pass the witness restriction.
Thank you. Mr. Gertz?
Mr. Fletcher's term of probation was set to expire in October of this year, is that right?
Correct.
And I understand a motion to revoke his probation was filed in July of 2025, is that right?
Correct.
He's continued to be on bond and now probation since that time, is that right?
Correct.
And supervised by you
Correct.
and compliant?
Correct.
And you didn't have any trouble communicating with him, did you?
No, sir.
He was polite with you when he would meet with you, visit with you, etc.
Yes, sir.
And he was generally compliant with the terms and conditions of his probation. You agree with that?
Correct.
I know he had some issues with marijuana during his time on your probation, but setting aside the new offenses, he was generally a compliant probationer. Do you agree with that?
Yes, sir.
That's what it's just.
I have no further questions for Ms. Baez. The motion be excused, Judge.
Any objection?
No, Judge.
Thank you, ma'am. Your excuse. You may call your next witness.
The state calls Officer Jeffrey Busby.
Officer Busby. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can have a seat. And Detective, if you'll just kind of pull that microphone close so we can all hear you. Thank you.
Please state your full name for the court reporter.
Jeffrey Busby.
And could you help me with the rank? I referred to you earlier as officer. Is it actually detective?
I'm a detective.
I apologize. Detective Busby, how are you employed, sir?
I'm employed with the City of Beaumont Police Department
How long have you been with BPD?
since 2014, so it's over 11 years.
Very good. I'm sure the court's familiar with you and your background and training. I'm not going to spend any time on that, but I will ask you, back in July, specifically on July the 4th of 2023, as part of your duties, what, if anything, caught your attention at around 7:07 p.m.?
So on that particular day, Sergeant Pratt and I were operating as a two-man unit, and we're patrolling. I observed a vehicle with a tinted front windshield that caught my eye, the area of East Tech Service Road and Lucas. And that being clear violation, that's what caught my attention. So eventually I conducted a traffic stop on that vehicle.
East Lucas and East Tech Freeway, that's in the city of Beaumont in Jefferson County, Texas, correct?
Yes,
Once it caught your attention, what, if anything, did you do next?
So it was at the intersection. It was going to indicate a turn onto Lucas. I waited for it to make its turn. And then from there, I got behind it and activated my lights to initiate a traffic stop. And we came to a stop in the Home Depot parking lot, which is the 4200 block of East Lucas.
And I'm assuming you made contact with the operator of that vehicle?
Yes, sir.
And when you made contact with that operator of the vehicle, was the operator of the vehicle the sole occupant of the vehicle?
Yes, sir.
And what, if anything, did you observe or experience?
So as I was approaching the vehicle, the tent was excessively dark on the sides also. So I called out to the driver to roll all the windows down so I could see inside the vehicle as far as for safety. And then once I made contact with him, I immediately smelled the strong odor of marijuana coming from the vehicle.
And are you familiar with the distinct odor of marijuana through your training and experience?
Yes, sir.
And the driver, the sole occupant of the vehicle, was he identified?
Yes, sir.
And who was he identified to be?
So Larry Fletcher Jr.
Larry Glenn Fletcher Jr.
Yes, sir.
Do you see the individual identified that day as Larry Glenn Fletcher Jr. in the courtroom today?
Yes, sir.
Would you please point to him and identify him by an article of clothing that he's wearing?
Here in a light tan color polo.
I asked the record reflect the witnesses identify the defendant.
The record will so reflect.
What did you do next?
So after I made contact, smelled the odor of marijuana, asked for his ID. His ID was above his sun visor around that area, so he handed it to me. And then as I was briefly speaking with him and smelling marijuana, I went ahead and had him exit the vehicle.
Okay. And what, if anything, did he admit to you after exiting the vehicle?
So as either right before he exited or as he's exiting, asking has any weapons in the vehicle, he says no. As he exits, we're getting to the car, asking is any marijuana, any weed in the car. He says yes, that he does.
Okay. And in addition to you smelling the distinct odor of marijuana, the defendant has now admitted that there's marijuana in the vehicle. And did you obtain consent to search the vehicle?
I did. I asked if I could search his vehicle, and he said I could. I had a probable cause already, but he also gave me consent.
That was my next question, is whether or not you even needed consent.
Yes, sir.
All right. So you conducted the search of the vehicle. What, if anything, did you find?
So I first checked where he was sitting at, which is around the driver's seat, and underneath the seat, I saw a black handgun. When I looked under the seat, the handgun was pointing at me, so the barrel was facing towards kind of the gas pedals. That kind of caught my attention, and behind it, I could also see a small container to the silhouette. It looked like large marijuana buds. So after I seen the firearm, I went and placed him in handcuffs because he originally said he didn't have a firearm. Now he does. That really brought my suspicion up on why he would lie.
Anything else was in addition to the firearm and the marijuana in the front seat? Anything else that was found in the vehicle?
Yes, sir. After I placed him in handcuffs and got him secured, I continued my search and found a Nike black backpack. It was white and black in the back passenger seat area, and that contained a larger amount of marijuana.
What, if anything, was tell the court how the marijuana in the backpack was packaged?
So it was originally this vacuum sealed bags, and the bags looked like they were in 1 pound increments, but that wasn't the total weight. It was going to probably be around 1 to 2 ounces in each bag, but the bag itself is 1 pound bags vacuum sealed. And also inside the backpack was a functioning digital scale. Anytime I see a scale, I'll see if it's functioning to make sure that it is true, because if you have a functioning scale, it means that they're more likely using it regularly.
Okay. And based on your training and experience, where you've got individually wrapped baggies of marijuana, you've got a firearm, you've got a digital scale, based on your training and experience, what is that typically indicative of?
For me, you're either a narcotics trafficker or you're a high-end buyer.
And in addition to the defendant admitting that there was marijuana in the vehicle, based on your training and experience, are you familiar with the appearance of marijuana?
Yes, sir. During this period of time, I was a narcotics detective. I have many years experience leading up to this, but this particular time I was assigned to narcotics as a detective.
And this substance that he identified as marijuana was consistent. Is it your testimony is consistent with the appearance that you know to be marijuana?
Yes, sir.
Based on all of those things, did you form an opinion as to what, if any, laws this defendant had violated?
Yes, sir. Other than the traffic violations, placed him under arrest for possession of marijuana and the UCW.
possession of marijuana in violation of Controlled Substance Act, section 481.121,
Yes, sir.
and a UCW unlawful carrying of a weapon in violation of section 46.02 of the penal code.
Yes, sir.
What made that a UCW, how did you get there?
So whenever you have a UCW charge, you can reach it a few different ways. For this, he has committed another offense other than traffic. So with the marijuana, it was going to be a minimum of a Class B misdemeanor. So that gives you the UCW.
Very good. Were you outfitted with any recording device or devices that day?
Yes, sir, I was.
That would be in the form of a body worn camera, correct?
Yes, sir.
As far as you know, was that body worn camera properly operating that day?
Yes, sir.
You, as the operator of that body worn camera, is certainly capable of properly operating it, right?
Yes, sir.
Was this encounter between you and the defendant captured on your body worn camera?
Yes, sir.
May I approach the witness, Judge?
Yes, sir.
Detective Busby, I am showing you what I am marking as State's Exhibit number 1. For the record, what type of a device are we looking at here?
It's the USB thumb drive.
Do you recognize that USB drive?
Yes, sir, I do.
How do you recognize that USB drive?
So I have a piece of paper here, my initials and the date that I've observed this and observed the recording on there.
And what date was that?
It's today.
Just before you testified?
Yes, sir.
Your Honor's time state on stage 1. Well, and the contents of this video, are they true and accurate with no alterations and deletions as far as you?
Yes, sir.
Office states 1 judge, tenured to defense counsel for his inspection. I might add, it was also provided to defense counsel discovery.
Judge, we have no objection to the video itself.
So states 1, no objection.
States one, no.
Okay, it's admitted.
And let me be clear, Judge, if this were a trial, we might be having a motion to suppress hearing about the tent issue. Obviously, I'm going to argue that later. So I'm not objecting because the court gets to look at everything anyway.
Sure.
So I'm doing that strategically so we don't sit here and waste time with that.
Thank you.
Just so the record is clear that I'm aware of that problem and we'll address it at an appropriate time.
Thank you. All right,
Thank you.
it's admitted.
Thank you. Permission to publish, Judge?
Yes, sir.
Roll all your windows down, sir. Roll all your windows down. Thank you. Do the other side too. And also most of them up always drive black and real fast. Get your insurance.
Report detailing your involvement in this case?
Yes, sir, I did.
Did you do it at or near the time when these events were still fresh in your mind?
Yes, sir.
Did you review it prior to testifying here today?
Yes, sir.
No further questions. I pass the witness, Judge.
Thank you, Mr. Coleman. Mr. Gertz.
Detective, do you have some kind of instrument that you use to test out whether someone's temp is over the 25% level or not?
Yes, sir, I do.
Okay. I noticed that you immediately had him, Mr. Fletcher, roll down each of his windows.
Mhm.
I also noticed, at least in what I saw here, that you did not use that instrument on his vehicle. Is that correct?
That's correct.
The Texas Transportation Code lays out the percentage that you're allowed to have or not have of tint in terms of the amount of light that can get through it. Is that correct?
That's correct.
when you observed him driving the vehicle before you initiated a traffic stop, were you next to him or were you passing him?
It would have more than likely been passing him.
You don't recall?
Well, I don't recall because I don't see on the video, but I recall the day. And whenever me and Sergeant Pratt were working, we were in the north end and we were going towards the west end because that's kind of a typical path I take. And Mr. Fletcher would have been on the service road to my right as we passed, and that would have caught my eye because working interdiction, illegal front windshield, like the 10 on the front windshield catches my eye. It's something that I look for, and that would have caught my eye. So I would have turned around and waited for him to get his green light so I can get behind him and conduct my stop. Because I believe on this particular stop, his registration was cut out around the tent. So you could see the difference between the registration having no obstruction and the tent itself on the front windshield.
Okay, but so your testimony is that he's not allowed to have any tent on the front windshield.
As long as it's not below the AS1 line, approximately 3 to 4 inches from the top of your windshield, there's an AS1 line that's indicated.
Yes, sir.
Now, if you get an aftermarket windshield, it might not have that AS1 line there, but you can't have tint below that AS1 line unless you have some type of disability and you have a letter saying you can have this from a doctor.
Did you, each of the, when someone puts tent on windows and windshields, et cetera, they're required to have a certification sticker on there, are they not?
They should, but not everybody puts those certification stickers on there.
Sure, but did you observe whether or not these had any kind of certification on them or not?
No, sir, and I wouldn't have, because of my questioning, I might have not have looked at that because he says he buys the vehicle like that. Because if he'd have said, I put it on there, my follow would have been, well, do you have a medical reason? Giving him a reason for this.
Did you ask him when he bought the vehicle?
I did not,
Did you ask him how long he'd owned the vehicle?
not that I can recall.
Okay. Judge, I'll pass the witness.
All right, thank you.
I have no further questions for the Detective Busby.
Any objection to Detective Busby being excused?
No, Judge.
No, Judge.
Thank you, Detective. You're excused.
Thank you all.
You may call your next witness.
This day called Officer Gabriel Fales.
Felds.
Fales, Fells.
Thank you. Good morning, sir.
Morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat. I'm gonna just kind of move that microphone over a little bit so we can all hear you. Thank you, sir. You may proceed.
Thank you, Your Honor. Good morning. Would you please state your full name for the court reporter?
Officer Gabriel Fells.
And Officer Fales, if I can get you to speak up a little louder, I want to make sure that everybody has a chance, especially the judge, to hear you. How are you employed, Officer Fales?
How am I employed?
Yes, what do you do for a living?
I'm a police officer in the city of Beaumont.
How long have you been with BPD?
8 years.
And your duties, what do they include?
Patrol, so answer calls for service. I'm an FTO, so I train rookies. And
I'm
I'm
gonna
on
ask you
SWAT.
to speak up a little bit. I'm sorry.
And I'm also on the SWAT team.
Thank you.
Were you working on September the 18th of 2024?
Yes, I was.
And at around 8:30 p.m., what, if any, dispatch did you receive?
I got dispatched to a major traffic accident.
And was the location given?
It was.
Do you need to look at did you bring a copy of your report with
I
you?
did not bring a copy of my report.
Well, this has happened quite some time ago. Would it help to refresh your recollection if you were able to refer to your report during your testimony?
That would be great.
Now, of course, would
You may.
Yeah, just at any time, feel free to look at this. What was that location?
Brooklyn and Grant
And that would be
in the city of Beaumont.
City of Beaumont, and is that in Jefferson County, Texas?
Yes, it is.
All right, and when you arrived, what, if any, observations did you make?
When I arrived, I saw a white Cadillac in the middle of the road, front end damage, and then a Honda in like the little grassy area. I believe it was in the grassy area, with side damage, driver's side damage.
Okay. And were there, first with the Cadillac, was there anyone in the Cadillac when you arrived on scene? If you recall.
I don't recall. I mean, I did watch my video before I came in here, but I don't think there was anybody in that car.
All right.
I think he was sitting on the side.
Okay. What about the Honda? Where was it occupied?
It was occupied by two people.
Black male driver, if you remember? That's a.
I don't remember. I'm sorry.
All right. Would it help? Take a look at the report, see if it's in your report.
Yeah, it was a black male, black female,
All right. Who was in the driver's seat, if you can tell?
black male.
How would you characterize, I mean, were they moving around?
They were not.
All right, and, okay. Are you familiar with the speed limit on that, in that particular area on Grant Street?
No, but it's residential, so I'd assume 30.
Okay. Did you at some point speak with the driver of the Cadillac?
I did.
At some point, was the driver of that Cadillac identified?
He was
And who did he well, you actually looked at his driver's license.
on his phone.
On his phone. What was his identity based on that driver's license?
Larry Fletcher.
Did he give you a date of birth, or was there a date of birth reflected on that driver's license?
Date of birth 12/12/92.
And if you recall, what, if anything, did he say to you about what happened?
He said he was driving down the road and someone ran a stop sign.
Did he say anything about applying brakes?
He said that he slammed on his brakes trying to avoid the collision.
And was he offered medical treatment?
I offered it. He said that he didn't need it. He said his leg hurt. But he felt the other occupants of the Honda needed it more.
Okay. In fact, were they extricated by Beaumont Fire and Rescue?
Yeah, they were.
And were they transported to St. Elizabeth Hospital?
To my knowledge, yes.
And to your knowledge, did the black male survive his injuries?
I honestly don't know. I didn't know until
Okay,
I was
well,
coming in here.
Let's leave it at that. Were you outfitted with body-worn camera equipment that evening?
Yes, I was.
And as far as you know, was that body-worn camera properly operated?
Yes.
And the scene as you observed it that evening, was it captured on your body-worn camera?
Yes.
May I approach the witness?
Yes, sir.
Officer Fells, I'm showing you what I'm marking as State's Exhibit number 2. I'll ask you first, for the record, to identify what kind of a device are we looking
The USB.
for. Do you recognize this USB?
Yes, I do.
How do you recognize this USB?
Because that's what I watched my video on.
And are these your initials?
Yes, they are.
And when did you watch this video?
Today.
Before you came in to testify?
Okay.
And is it a true and accurate copy as far as you can tell with no alterations or deletions?
Yes.
All right. Now, at this time, State Officer States 2, tenure to defense counsel, was also provided any discoveries.
We have no objection, Judge.
States 2 is admitted.
Permission to publish, Judge.
Yes, sir.
What's going on there, officer? What's happening?
Looks like fire is trying to extract a drug.
Anybody speak like that?
I don't know if you want to monitor.
Yeah, so obviously you guys see what's about to happen. So if you don't want to see that, now's a good time to excuse yourself from the courtroom if you don't think you can handle that.
Judge, I apologize.
That's okay. I should have caught it as well. You go back.
Officer Fails, what are we looking at here? Is that Honda you testified about?
It is.
And it's occupied by the black male and the black female that you testified about earlier, correct?
Yes.
For the record, we're about 7 minutes and 13 seconds into the video. Who are you making contact with at this point?
Mr. Fletcher.
Yes, sir.
Officer Fails, you essentially just identify him from that at that point. Correct?
Correct.
And was the defendant formally interviewed by you, or was he interviewed by another detective? If you know.
On the initial investigation, I asked him what happened, and he told me that he was just driving. Someone ran a stop sign.
I guess my question, what I'm trying to get at is, could he have subsequently been interviewed by a detective that you're not aware of?
I'm not aware of it.
Okay, good. Did you prepare a report that detailed your involvement in this case?
I did.
Did you prepare that report at or near the time when these events were still fresh in your memory?
I did.
And did you obviously were reviewing this report throughout your testimony, correct?
Correct.
All right. I'll pass the word, Mr. Judge. Let me get that copy back.
Thank you, Mr. Coleman. Mr. Gross?
Okay, are you
Good.
good? Let's talk about that intersection that we're dealing with here. It appeared that Mr. Fletcher was driving eastbound on Grant. Is that fair?
Yes.
Yes. So Grant is 2 blocks away. Essentially, it's a street that starts at Irving Street. Is that right?
I believe so. I'm really not familiar with the south end
Okay.
of Beaumont.
But it's not been. I mean, if somebody's driving Map, what's the
Yeah, sure.
show you a map. Yeah, that might probably makes it easier. So this North-South Street here is Irving.
Mhm.
Familiar with that? And to the west of it is Charlton Pollard Park.
Yes,
Okay, and this accident happened at Brooklyn and Grant, is that correct?
yes,
And you agree with me that that's within 2 blocks of Irving, is that correct?
correct.
And Mr. Fletcher was driving eastbound on Grant.
Okay,
Do you agree with that?
yes,
And the vehicle that he collided with was driving northbound on Brooklyn. You agree with that?
yes.
Okay. Now, at that intersection, Judge, would it help you to see this?
Well, I mean, if y'all don't care, I'm just gonna look at a map.
Okay, that's fine. Hey,
Any objection to me pulling up my map? Okay.
now, that intersection is a controlled intersection by a stop sign, is that correct?
Correct.
And the people driving on Brooklyn Street, anyone driving on Brooklyn Street would have a stop sign there at Grant, is that correct?
They would.
And they are supposed to yield to other vehicles that are going east-west on Grant, correct?
Yes,
That's what the law requires. Agree with that?
correct.
Have you investigated a number of vehicle accidents?
Yes,
Okay. Have you written few or many tickets for people failing to yield to oncoming traffic?
I've rode many.
Many, okay. And the reason for that is because the statute says you must yield to oncoming traffic. Is that correct?
Correct.
The statute does not say you must yield except if they're speeding, right?
Mhm.
I'm sorry, you got it. Not being
Yes,
difficult. You got to give me a yes or no.
yes,
It doesn't give any exceptions. It's a mandatory required conduct. Is that right?
that's right.
Failing to yield is always a violation of that statute. Is that correct?
Correct.
And in this case, there was no stop sign on Grant, correct?
There was not.
So Mr. Fletcher wasn't controlled by a stop sign, correct?
No, he wasn't.
It was the driver of the Honda that was controlled by a stop sign, correct?
Yes,
Now, I noticed on there, I could clearly see Mr. Fletcher's vehicle on the video. Could you see it clearly?
yes,
It wasn't obscured by a bunch of vehicles or anything else, was it?
no,
And there wasn't some vehicle illegally parked that would block the view of someone at Brooklyn and Grant or something like that, correct?
no.
Not from what we saw in
Not
the
what
video.
I saw, no.
And I expect you may not have an independent recollection of all of that, but we saw it on the video, right?
Right,
And that aside from Mr. Fletcher's car being in the intersection, there wasn't any cars on Grant that would obscure view. Is that correct?
correct.
Okay. And so what logically seems to have happened, if those two vehicles come into contact with one another, Mr. Grant would have the right, Mr. Fletcher on Grant would have the right of way, correct?
Correct.
And the Honda would be required by law to yield to Mr. Fletcher's vehicle. Is that correct?
Correct.
And that appears not to have happened here. Is that right?
Correct.
That's what it's doing.
I have no further questions for Officer Bales, Your Honor.
Any objection to Officer Phelps being excused?
Thank you.
Well, just, actually, one quick question. I apologize.
Sure, go ahead.
I was holding to that, Judge. I have a quick question.
Officer Phelps, you were not an eyewitness to this crash, right?
I was not.
You arrived, it goes without saying you arrived after the fact, correct?
Yes, I did.
All right, that's all, Judge. Thank you.
That was
Anything else then to follow up? Thank you, sir. Your excuse. You may call your next witness.
State called Justin Dilbeck,
What's the last name? I'm sorry.
Dilbeck.
Dilbeck, Justin Dilbeck.
like not trial 101. Don't commit to one question.
What is an actual street address close to there?
800.
You would think.
And Brooklyn.
Yeah, Grant Brooklyn doesn't quite work. So
800 block, 800 block.
800. Thank you. Good morning, sir.
Good morning.
If you'll please raise your right hand. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth. Thank you, sir. You can have a seat. And if you'll just pull that microphone kind of as close as you can get it, make sure you speak loudly and clearly so we can all hear you.
Okay.
Thank you for being here, Mr. Dilbeck. Would you please state your full name for the court reporter?
Justin Corley Dilbeck.
And Mr. Dilbeck will be brief. Your testimony, I hope, will be brief because we've heard from a witness or two already about this, and we've seen video from the scene. But what I want to ask you is, back on September the 18th of 2024, how were you employed?
It's Captain Engine 11, City of Beaumont Fire Department.
City of Beaumont Fire Department, correct?
Yes, sir.
And were you dispatched to a crash at around 8:30 on that evening?
I believe so. I'm not sure of the time exactly, but
Please, if you got your
I've got my
report,
report.
feel free to refer to it. I know it's been a while.
yes, sir. Yes, sir.
Okay. And what was the nature of that dispatch?
It was an MVA, 2-vehicle MVA.
Meaning motor vehicle accident?
Multiple vehicle, motor vehicle accident.
All right, and when you arrived, what did you observe?
Observed, I don't know if it was family members or neighbors, but people point me in the direction of a vehicle with people trapped inside.
Okay.
And just began the patient assessment at that time with what I had.
And what I want to focus on, because it was a two-vehicle accident, but I want to focus specifically on the vehicle that had people trapped inside. And why I called you as a witness is I want you to impress or let the judge know your take on the level of damage to that vehicle. What, if anything, stood out to you about that?
I was caught off guard because I worked that area for a long time. Never worked a crash with that much damage. Usually in that neighborhood, it's a lower speed impact. It was the vehicle was completely off the roadway, and then when I made my way around to the driver's side, I had significant intrusion into the driver's side door.
In fact, you or someone called for an additional engine.
I did.
Is that why would you do that?
It's standard to request more manpower whenever we begin extrication of patients.
And in fact, extrication was used to remove the door by cutting off the hinges and the locking mechanism, correct?
That's correct.
Was that used done by what we commonly referred to as like the jaws of life?
That's correct.
Okay. Mr. Dilbeck, thanks for being here. I know your testimony was brief, but that's kind of what we needed to, what I needed to get in front of the court. Thank you.
Thank you, Mr. Coleman. Mr. Gertz, any questions?
No, Judge.
Any objection to Mr. Dilbeck being excused?
No, Judge.
No.
Thank you, sir. You're excused.
Thank you.
You may call your next witness.
We're on a state called Carol Hargoder.
Carol. Good morning. Good morning. If you'll please raise your right hand, please swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth. I do. Thank you, ma'am. You can have a seat.
Please state your full name for the record, please.
Carol Hartroder.
Ms. Hargoder, how are you employed, ma'am?
I'm an ID tech with the City of Beaumont Police Department.
As an ID tech, were you dispatched back on September the 18th of 2024 to Grant and Brooklyn in Beaumont?
September the 19th, I believe.
Right. Oh, yeah, September the 19th. Was that like in the early morning hours?
No, it was in the evening. I'm a nighttime tech.
Okay. I want to make sure that we've got our dates right. Do you have a report?
I do, and I may have my date wrong. I've got the 19th.
If other witnesses put September the 18th in their report, you wouldn't have any reason to disagree with that, would you?
No,
Could have been possible that you just kind of got your dates wrong.
yes, it certainly could.
All right, and when you arrived as part of your duties, did you take photographs of the scene?
Yes, I did.
May I approach for you, Ms. Judge?
You may.
I'm showing you what I've marked as state's exhibits 3 through 6, 3, 4, 5, and 6. I ask that you take a look at those and let me know if you recognize those.
Yes, I do.
Are these photos from the scene that evening that you took?
Yes,
And are they fair and accurate depictions of the scene as they appeared that day?
yes.
At this time, State Office 3 through 6, I'm tenured to defense counsel for this.
We're not the objection.
States 3, 4, 5, and 6 are admitted.
I just would like to publish these to the court, please. Ms. Harbroder, your testimony was brief. Not unlike the last witness, we've already seen video from the scene. However, I just wanted to make sure we get those photos in as well. That's all I have, Judge. I'll pass this witness.
Mr. Gertz, any questions?
Ms. Hargrove, was there, was this all the pictures you took or were there additional pictures?
Yeah, there were several more.
Okay. I noticed that at Brooklyn and Grant, there is a stop sign that you photographed. Is that right?
Yes,
The people driving on Brooklyn have the stop sign. Is that right?
yes, sir.
Not the people on Grant, correct?
Yes, that's correct.
Pass the witness, Judge.
Thank you, Mr. Gertz. Anything else, Mr. Coleman?
No, Judge.
Any objection to Ms. Harbroder being excused?
No, Judge.
No.
Thank you, ma'am. You're excused. You may call your next witness.
State calls Darlene Wisby.
Good morning, ma'am. Could you please raise your right hand? Do you swear or affirm the testimony given this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can have a seat. And if you'll just kind of pull that microphone close, make sure we can all hear you. You may proceed.
Thank you, Your Honor. Good morning. Would you please state your full name for the court reporter?
Darlene Wisby,
And how are you employed?
with the Beaumont Police Department, Traffic Division,
How long have you been with BPD?
44 years as an officer.
And I am the worst with remembering the rank, so please, your rank for the record, what is it?
Grade 1, patrol officer.
Okay, all right. And I'd like to ask whether or not you had an opportunity to respond to a dispatch back on September the 18th of 2024 around 8:30 p.m.
Yes,
Where was that location?
Brooklyn and Grant.
Okay, and we've already heard testimony from a couple of witnesses. We've even seen video. So I'm not going to spend a lot of time with you about the scene, other than to ask you whether or not the driver of the Honda that was involved in that crash was identified.
Yeah, the Honda identified. Excuse me. I don't have my record report, but the Arthur Thomas.
Yeah, do you need, what do you need your
I have
report?
just to invest. I don't have the record report.
May I approach witness?
Yes, sir.
Do you need this or do you need that?
This is I have a copy of that.
Okay.
Excuse me. Arthur Lee Thomas was the driver of the black Honda.
All right. Do you have a date of birth for him if it's listed?
Yes, it is listed. 10/24/65.
And the passenger of that Honda, was the passenger identified?
Yes.
Who was the passenger identified to be?
Birder, Birder, Harrington Thomas.
And do you have a date of birth for her?
I don't have it on the record report. She's 57 years old.
Okay, that's what I was getting, so. And the conditions of these individuals, did you learn of what happened to Arthur Lee Thomas?
He died due to the wreck.
Okay, and the condition of Berta Harrington Thomas?
She had severe injuries.
And we've had testimony about the nature of the damage and the location of the damage on the vehicle, so I'm not gonna spend a lot of time on that. But did you get a chance to talk to a witness, at least one witness there at the scene?
Let me see which witness. I don't have, the officers are the ones that gave me the information as far as witnesses and stuff go.
No problem, that's fine. In fact, I wouldn't want you to say what was told to you anyway, because that's hearsay. I
Right,
just want to give the court an idea of what all your investigation encompassed. So you at least talked to officers or reviewed the officers' reports who talked to witnesses there at the scene. Right?
correct.
Okay. And the speed limit there on Grant, are you familiar with that?
Yes, it's
What?
30.
30 miles per hour.
Yes,
All right. And have you yourself investigated few or many motor vehicle crashes?
I have.
And the extent of the damage here, in your opinion, would it have been consistent with someone who was traveling around 30 miles per hour?
The person who hit Mr. Thomas, it would not be.
What would it be, again, in your training experience, more indicative of?
A
I'm not
higher
trying to pin you
speed,
down on the exact speed,
a
but
greater speed.
I think that's a fair way to answer that. Now, in addition to reviewing the reports of the officers and who talked to witnesses on the scene, did you also review the fire department or EMS reports?
I usually get them, yes, but I can't tell you what they said. I
Okay.
don't have a copy of them.
Not asking you what they said, that's hearsay. I just want to give the court an idea that this was part of your investigation, all right?
Right,
Okay. And did you also, you or someone secure a search warrant to obtain the crash data or the airbag control module, what's commonly referred to as a black box, from that Cadillac?
I did.
Okay. And pursuant to that search warrant, did you enlist the assistance of Robin Wright to obtain or remove or download that data?
Yes,
And was that also something you considered as part of your investigation?
yes,
Okay. And did you prepare a crash report?
I did.
And does that crash report contain a diagram of what you believe happened?
Yes,
Or how, not what you believe happened, but how the scene appeared, at least to you?
yes.
Okay. Is there a VIN number? This is gonna be, I think, important later on, but with regard to Mr. Wright's testimony, was there a VIN number listed on your crash report for the Cadillac?
There is.
Would that be 1G6K P5R67K U122071?
Yes,
And if I can get that crash report back from you, I'd like to at least show the diagram. Would it assist this court in understanding your testimony if we were able to utilize the diagram?
sure.
She said she.
I didn't answer that. You can take on board that.
Officer, did you make this diagram yourself
Yes,
based on things you observed at the scene?
yes.
Then I have no objection. And really all of this,
I'm not gonna offer it.
okay, that's fine.
Your Honor, permission to utilize the diagram as a demonstrative.
Sure.
Only alone.
Any objection to him doing that?
Not to that portion of the,
Okay.
yeah. top part's not important, it's the other, it's the back side, the other side, but I would object to it. You're fine, I'm just gonna show you this. That's totally fine. Yeah, I'm sorry. I'm saying you don't have to fold it.
Okay. Officer Wisby, it's kind of unwieldy over here with this Elmo because I have to put the document on the thing upside down. It's weird.
That's all right.
Bear with me.
There should be a button to flip.
I can figure that out.
See how his motor skills are, Judge?
Yeah. Again, that's probably as good as I can get it. Officer Wisby, there's a screen behind you.
Right.
There's probably a pointer somewhere up there, either a laser pointer or like an actual physical pointer. Maybe good for you to utilize it for your testimony. Just explain to the judge what we're looking at here. First, starting with the streets and the lanes of travel.
Okay, let's start with this first. This is north, this way. This street right here is Brooklyn. This street is Grant.
Grant, okay. And Mr. Gertz has pointed it out with other witnesses, and I'm sure he'll point it out with you that there's a stop sign, and where's that stop sign positioned?
Stop sign here,
So for the
Or-
traffic on Brooklyn.
Brooklyn, correct.
Now, you've got units marked here, unit 1, unit 2. What does unit 1 represent?
This vehicle is Mr. Fletcher's vehicle, the Cadillac.
Yes, ma'am.
And this is Mr. Thomas's vehicle,
For purposes of the record, we're talking about unit 2.
Unit 2.
Okay. Now, unit
It's
1
fine.
and unit 2 at this point is like a silhouette. What does that mean?
Like an outline, they
Outline.
weren't
Yeah.
there. They weren't in that position
Okay.
when I arrived at the scene. That's where I was told they had the direction of travel and where they were coming from.
Now, the outline, there's the outline version of unit 1 and the outline version of unit 2, but then there's also a darkened in version of 1 and 2. What does that represent?
That's where the vehicle was when I arrived on the scene.
When they finally came to rest?
Mr. Fletcher's vehicle,
Yes,
Mr. Thomas's vehicle is Unit 2.
based on your training and experience and the positioning of these vehicles and your investigation. What did you surmise happened here?
Okay, there was damage to the Mr. Thomas's vehicle, the driver's side. Damage to Mr. Fletcher's vehicle in front.
Was-
So I was told that
Well,
Mr.
let's not talk about what you were told. That's gotta be a hearsay
Okay.
objection. It's just the fair, I guess what I'm getting at, because you weren't an eyewitness. It looks like based on the diagram and your observations, that the front of that Cadillac struck the side of that
Correct.
Honda.
Correct.
Okay, all right. At a speed that you previously testified to, based on your training experience, that would have been in excess of 30 miles an hour or so.
Yes, it would not, it'd be much greater than 30 miles an hour.
That answers my question. We'll get testimony from Mr. Wright about the crash data, airbag module data. But based on that data, and I don't want you to testify to it, but based on that data, based on the officer's reports and the witness accounts on scene, and your training experience, did you form an opinion as to whether or not a criminal offense or offenses had been committed?
Yes,
What was that opinion based on all of those totality of circumstances?
about who, you're asking who caused the wreck?
Well, this defendant was charged with a criminal offense or a couple
Right.
of criminal offenses.
What was it?
Well, did you form an opinion as to, based on all those things, as to what, if any, criminal offenses were committed?
Yes, I did.
What did your investigation lead you to believe?
Manslaughter.
All right, and aggravated assault,
Yes, on his wife
who survived?
who survived.
You prepared a report, right, at or near the time when these things were still fresh in your mind, right?
Yes,
You reviewed that report prior to testifying today?
I did.
Thank you for being here. I'll pass it with Mr. Judge.
Thank you, Mr. Coleman. Mr. Gertz?
How are you?
Good, how are you?
Good to see you again. Sorry, we all keep meeting under these circumstances. You're familiar with the Texas Transportation Code, are you not?
I'd have to look up. I don't know these things by heart.
Sure. I'll tell it to you, but you're familiar with the offense of failure to yield the right of way.
Yes,
And that statute says that if you have a signal controlled that controls your activity, like a stop sign or stop light, you are required to yield the right of way to a vehicle who does not have a controlling signal. Is that correct?
true.
It is a strict liability offense, is it not? It says you must do this.
Yes,
It's not optional, right?
correct.
And if a vehicle neglects to, or a person operating a vehicle neglects to yield the right of way, they are a cause of the accident. Is that correct?
Possibly, yes.
Okay. Is there ever a time, and there's no exception in the statute that says, unless the other person is speeding or something, right?
Not that I'm aware of, no.
And I suspect in your experience, you've had lots of people who failed to yield the right of way tell you, but the other car was speeding, right? And you still go ahead and write them a ticket for failing to yield the right of way, correct?
Probably, yes. I would have to say probably, yes.
Okay,
Unless I can prove the speed.
sure. But I guess what I'm getting at is I mean, if you fail to yield the right of way, you are a contributing cause to that accident.
Yes,
Regardless of what the other person is doing, correct?
unless I have proof of something else.
Okay. In this situation here, we just saw the diagram. There was a controlling signal or controlling stop sign there at Brooklyn going northbound, correct?
Correct.
Grant Street did not have a
They did not.
stop sign. So Unit 1, the Cadillac, had the right of way for that intersection. Is that correct?
Correct, at 30 miles an hour.
But had the right of way at
Yes.
that intersection.
Yes,
And the Unit 2 was required under the law to yield that right of way to Unit 1, correct?
from a stop sign, you were to yield to oncoming traffic.
That's what instruction.
Nothing further for Officer Wisby, Judge?
Any objection to Officer Wisby being excused?
That's Judge.
No, yeah.
Thank you, ma'am. You're excused. Let me call your next witness.
The state calls Robin Wright.
Robin Wright. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat. And if you'll just kind of pull that microphone the best you can and make sure we can all hear.
Yes, ma'am.
Thank you. You may proceed.
Thank you. Good morning, Mr. Wright. Would you please state your name for the court?
Robin Wright, WRIGHT.
Mr. Wright, I ask that you speak up a little louder. I want to make sure everybody can hear you, particularly the judge. Thanks for being here. I know you got a lot going on right now. We'll try to get you out of here as quick as possible.
Thank you.
How are you employed, Mr. Wright?
I own my own business, RH Wright and Associates.
And did you have a previous life before that business or career?
I did.
And what was that, sir?
I was a state trooper for the Department of Public Safety here in Texas.
And how long did you do that?
34 years.
All right. What's the focus of your current business?
Crash reconstruction.
Crash reconstruction. And you've been trained, no doubt, in that area, in that field?
Yes, sir. Most of my training came from from DPS. However, I also went through training at Lamar University and Texas A&M University, and a host of certificate level courses that were offered to law enforcement and ex-law enforcement personnel.
If you had to put a number or estimate how many crashes you've investigated and or reconstructed, what would that number be?
It's close to 5,000.
done in a time or two. How did you become involved in this particular case?
Because I knew a lot of the people in the traffic division with Beaumont Police Department, I have downloaded a number of the airbag modules in their vehicles that were involved in crashes. I cut them a really good price and,
All right. So pursuant to a search warrant, did you in fact download an airbag control module, or what lay people like me refer to as the black box, from a vehicle involved in this case?
I did.
And if you got your report there in front of you, may be helpful for you to refer to that report. But that vehicle that you downloaded it from, was it a Cadillac CTS?
Yes, sir. 2019 model Cadillac 6.
Bearing VIN number 1G6K P5R67K U122071.
That's correct. That's what I've got.
And when did you remove? Is there a couple of ways to obtain that data from a airbag?
Yes, sir. There are a number of ways. The easiest and most expeditious way, of course, would be to plug into the data port under the steering wheel that all the mechanics plug into it and activate the CAN bus on the car.
Were you able to do that in this?
I was not, because we did not have the key fob for this particular car.
So you ultimately just had to remove the entire module? Is that what you did?
The alternate way is to remove the module and do it on a benchtop type situation.
That was my next question, is whether or not you performed a benchtop imaging on this. And I wanted to use that term so I could sound like I knew what I was talking about, because I got it straight from your report. But you benchtop imaged that airbag control module in this case, right?
I did, yes, sir.
And you did so using what type of equipment or software?
Bosch crash data retrieval software.
Are you trained or are you familiar with how to use that Bosch crash data retrieval software?
Yes, sir. I have attended 3 classes on it and a yearly convention for CDR users. That's what we refer to it as, CDR, crash data retrieval.
Have you used that software on few or on many occasions?
Many occasions.
Have you found it to be reliable software?
I have.
And is that software used widely by law enforcement?
Yes, sir, it is. And it is, I would class it as the industry standard.
Let's talk about the data that you received or downloaded using that software. I mean, in this court's familiar, so I'm not gonna spend a lot of time on it. The court's familiar with the different types of data and data sets that you can get from that module, particularly when the airbags are deployed, correct?
That's correct, yes, sir.
When the seatbelt tensioner is activated, correct?
That's correct.
You can also get acceleration and deceleration information, correct?
Correct.
Were you able to obtain all of that information in this case?
Yes, sir, I did.
Let's start talking about the deployment. Was the airbag deployed at or near the time that the crash was reported?
That would be a correct statement, at or near. It has to do with a mathematic formula to for that module to make the decision to fire the airbag.
And that would be termed as time zero, or the time of the crash, or thereabout?
Time zero is the time that the airbag deployed.
Yes, sir.
It is very close, within milliseconds of the a very few milliseconds of the crash itself.
Okay. And often when that airbag is deployed, does the seatbelt tensioner also, is it activated? Is that fair to say that typically corresponds?
Yes, it does.
Did that correspond in this particular case?
It did.
Now, with regard to the deployment of the airbag and the seatbelt tensioning, were there also correlated data as it relates to the max acceleration prior to impact?
Yes, the module stores data from prior to the impact for a total of 5 seconds before it overwrites it. So it's kind of a round file, if you would. So it's 5 seconds long, and it overrides anything that happened more than 5 seconds prior.
Please tell the judge what that 5 seconds prior to time zero or the crash was reflected or indicated by your download of this data.
That 5 second is referred to as the pre-crash data table. And it monitors whether the brake light switch is on or off, indicating application of the brakes, the accelerator pedal position in a percentage, the engine RPMs, which doesn't tell us a whole lot other than it was running really fast at that time. The engine percentage throttle, or throttle percentage rather, the vehicle speed indicated on the speedometer, and then it's got some power status data PIDs that are usually tell you that it's either running on power from the car, or it's on emergency power, or it's off.
You mentioned one of those data points being speed. Let's focus on the speed.
Yep.
What did your analysis show with regard to the 5 seconds prior to time zero or the crash as it relates to the speed?
The speed of the vehicle as recorded at 5 seconds prior was 52 miles per hour.
Now, what about 2 seconds prior?
At the 2 second prior mark, the speed was 72 miles per hour.
72 miles per hour, 2 seconds before time zero or the crash.
Correct.
I know you don't know what the speed limit was for that particular area. If you know, I don't know if you know or not.
I do not.
Okay, that's
I
fine. We've
know
had
that,
testimony
correct.
of that, but okay. So at some point, help me understand this or explain it to the court. It looks like 5 seconds out, we're at 52 miles an hour, and there was an acceleration 2 seconds out to 72 miles per hour.
Yes, sir. When the record starts at 5 seconds, the accelerator pedal position was at 99%.
What is that in your experience indicative of? What does that tell you in real world parlance?
He had it floorboarded.
Okay. And then about a second before time zero for the crash, what does the speed show?
Did you say 1 second?
Well, I'm looking at 1.99 seconds. Is that reflected there? Or am I getting that right or wrong?
Yes. So what I meant to convey when I wrote that was the brake light service switch goes from off to on between minus 2.0 seconds and minus 1.5 seconds in the countdown. So we don't know whether it was at 1.99 seconds or 1.51 seconds or 1.5 seconds. It could have been at any point in that half-second interval. So he did get on the brakes at some time between time 1.99 seconds before time zero and 1.5, because the 1.5 data PID shows brakes on. The previous one showed them off.
Yes, sir. And the final thing I'd like to address in your report would be, and by the way, before I forget, your written report does include all of those data points in written form, correct?
Yes, sir, they do.
Okay.
It does.
And one final thing about the braking effort. You have a line in there, it starts out with if the braking effort continued until the actual impact. That's an if, right? That's speculation, right, on your part?
Yes, because I don't have any data stating that he stayed on the brakes all the way through the time of impact. I was not at the scene. So I'm bound by only what the data tells me.
But if you extrapolate and you account for it, if he stayed on his brakes, what would the speed of impact? What would the speed have been at the time of impact? That's given he stayed on the brakes, and again, that's tantamount to being speculation on your part, really.
Yes, and I'll be glad to tell you how I got to
Please, because
that.
I just want to get out in front of this. I'm sure Mr.
Okay,
Okay,
the speed at the time of impact was about 40 miles per hour, provided he stayed in the brakes.
And if there's anything else you want to add to that?
Yes, sir. The interesting part about that is if you look at the accelerator pedal position, you see that it goes from 99 to 0 for 1 full second, and then it goes back up to 27, then back up to 42. However, the brake lights are still on. So that would mean a couple of things to me.
Yes.
As far as being able to read these reports and analyze them. He either drives with both of his feet, one on the brake and one on the accelerator.
Or is that a form of, I'm sorry to interrupt, but is that one form of how people do burnouts? Or am I completely off base?
It's done that way.
Okay.
I don't think that was the case.
I'm sorry to interrupt.
No problem. But that minor acceleration is going to affect his deceleration caused by the braking effort that he was applying or trying to do. So that's the reason that I can't be exactly sure what the speed, and the reason I referred to it as the speed at the time of impact was about 40 miles an hour. He had, if you will look at the reduction in his speed, he had lost 9 to 10 miles per hour per half second. So from 51, that would be about 40 miles per hour.
And let's just say, based not even on your training experience, but in your just everyday life experience, if a person is traveling 70 to 52 miles an hour in a residential neighborhood in a zone that's zoned for 30 miles an hour, is it fair to say it would make it difficult for someone to see that vehicle, that oncoming vehicle?
Seeing and judging the speed of that vehicle are two
I think that's a better way to put it.
different,
Right.
different
Judging the speed.
things.
Yeah.
It's very difficult it's very difficult for me to judge the speed accurately of a vehicle that's approaching. I have had a lot of training in that area, and I can usually say, oh, he's running pretty fast. But as far as knowing the neighborhood of how fast he's running would be just guesswork.
That's a better way to put it. And I should have asked it in that form about judging the speed as opposed to being difficult to see. Thank you, Mr. Wright. And again, thank you for being your past witness.
Yes, sir.
Thank you, Mr. Coleman. Mr. Kurtz.
Hey, Mr. Wright, how are you?
I'm fine. How are you, sir?
Good to see you. So let's talk about the pre-crash data table that you have there.
Yes, sir.
I want to be clear for the court that the unlike the accelerator position data, the brake switch is about whether or not the brakes are being touched at all, correct?
Yes.
It does not tell us.
It does not quantify the braking effort.
So the accelerator is quantified, the brake lights are not quantified.
That would be correct. Yes,
Okay,
sir.
so we can't tell how hard somebody's mashing down on the brakes, right?
That's correct.
But we can tell at least at some point how hard somebody might be mashing down on the accelerator.
We can't. That's correct. The only way that we can tell how fast he is decelerating is to look at the speed reduction as in the speed.
And that's an extrapolation that you make.
Yes, it is an extrapolation.
Okay. Here, let's be clear. You use the number 72 miles an hour at 2 seconds before impact. Is that correct?
Yes, sir. That was the highest speed that was recorded.
Okay. Now at a full 2 seconds in advance of the impact, though, his foot comes completely off the accelerator, correct?
That's correct.
And then in second 1.5 seconds before, his foot is on the brake in some manner or form, but we can't tell how hard, correct?
Yes, that's correct.
And it remains on the brake 1 second out, half a second out, correct?
Correct.
And you mentioned somebody maybe drives with both feet. Is it also possible, or would you make room for the possibility that maybe somebody's pressing with their foot on the brake because they weren't anticipating anybody pulling out in front of them, and they're just touching the gas while they're pressing hard on the brake because of the way their foot is?
I would have to admit that my feet are not big enough to do that, but I know some people's are.
Sure.
And
And
that
the
would
pedals
be
are
a
not-
possibility.
The
Yes,
pedals are not far away from each other, right?
they're not.
And oftentimes in a, I mean, you know this, you've investigated thousands and thousands of crashes. Oftentimes when something sudden happens, your immediate reaction is not rational or logical, right?
Sometimes it's not.
And it may not be perfect either, right?
That execution of that action is many times not perfect.
All right. Now, so what we can extrapolate is that at the time of impact, the vehicle was doing this vehicle was doing 40 miles an hour. Is that right?
Yes,
Extrapolation, right?
that's correct.
I just want to make it clear that that was not a determination. He said if.
Actually, I asked him if it was an extrapolation.
Sorry.
I think the court is clear on that. And he never, after applying the brakes, sometime after the 2 second mark, there's no evidence here that he ever took his foot off the brake, is there?
No, sir. The brake shows to be on for the remainder of the table here.
And the speed continues to decelerate, correct?
Decrease, yes.
And at 2 seconds, the accelerator is fully off, is that correct?
That is correct.
Okay, so a full 2 seconds before impact, the accelerator is fully off.
Yes, it's showing 0%.
Okay. Now, do you recall testifying in a case a while back that you and I dealt with over in the drug court involving a woman named Tanya Bowman? Do you remember that case?
Yes, sir, I do.
Okay. And remember that in that case, the key issue was whether one car was speeding or whether the other car failed to yield the right of way, right?
That's correct.
And you and I went round and round and round about it, did we not?
We did.
It felt like days, right?
It was a long time. It was.
And ultimately, your position,
I would object to the relevance of that other case in this particular case.
Judge, it goes directly to his opinion about this.
Overruled, go ahead.
Ultimately, your opinion was that if someone fails to yield the right of way, that they are the cause of the accident, in that case, regardless of the speed of the other vehicle. You remember that being your testimony?
Yes.
And so if someone pulls out and does not yield the right of way when they're required to by law, it was your testimony then, in that case, that regardless of the speed of the other vehicle, the failing to yield the right of way is the cause of the accident, right?
That would be correct, but I've got to qualify that answer just a little bit. We're dealing with two different speed limits, I think.
Sure.
I like to say, I did not work the wreck. There's a lot of difference in being a little bit over the speed limit and being a lot of the speed limit.
Sure. Well, just for a reminder, that car in that case was doing 73 miles an hour and a 55.
I will renew my objection about drilling down on the facts of that other case for the purposes of this case.
Judge, I allowed him to qualify his answer. He's testifying as an expert. I'm asked that he be heard as an expert in this space.
The facts, I mean, unless the facts are exactly the same, I mean, it sounds like there's some similarities, but with that qualification, I think I understand where Mr. Wright's got.
And I'm going to just clarify with this one additional fact for that qualification that I wasn't going to ask him, but now I'm asking him because he raised the qualification.
Go ahead, one more question.
Okay, so the vehicle in that case was that had the right of way was doing 73 and 55. Do you recall that?
I do.
And the vehicle, so that would be almost 20 miles an hour over the speed limit, correct?
Yes, sir.
In that situation. And the vehicle that failed to yield the right of way was the one that you felt like was the cause of the accident. Yes. Judge, I pass witness.
I have no further questions for Mr. Wright. Your Honor, may he be excused?
Any objection?
No, Judge.
Thank you, sir. You're
Thank you.
excused. Mr. Coleman,
State of Texas rest at this time, Judge.
thank you, Mr. Coleman. Mr. Burns, any witnesses? All right. So let's start with Mr. Coleman, argument with regard to not necessarily what with regard to the counts and whether or not they're true or not. You may proceed.
Judge, I won't belabor the point. You just heard the testimony. The testimony is fresh on your mind. I think I'll start with what I believe is not even a close call, which is the possession of the firearm and the marijuana. I think the evidence is clear on that, and it certainly rises beyond or more than a preponderance of the evidence based on the testimony and the video that supports the testimony, Judge. This is defendant violated condition 1 of his conditions of probation by violating the law, not only by possessing the marijuana and not only by possessing a firearm in furtherance of possessing that marijuana, but also, Judge, there was also evidence that he may have been also engaged in distribution of that. And I ask that you consider that as an aggravating factor for punishment purposes, Judge. With regard to the aggravated assault, Your Honor, likewise, I think you've seen the videos, you've seen the photos, you've heard the testimony. I think Robin Wright made a very good point that I didn't think of. Even if you are of the opinion or you believe that there was some failure, and I'm not conceding that, but if you believe there's some failure to yield the right of way, I would submit to you that an individual traveling 72 miles an hour, at most 52 hours at minimum, would make it difficult for someone to judge or recognize that that vehicle is coming at them that fast, Judge, in such a short time frame span. So I ask the court to consider that, Judge, in determining whether or not the defendant acted negligently or recklessly with regard to not only the aggravated assault, but also the manslaughter as well, Judge. And with that being said, I want to make sure I cover everything here. I think that's really all I have on that, Judge. Thank you.
Thank you, Mr. Coleman. Mr. Gertz.
Judge, as to the first set of allegations regarding the alleged marijuana, there's no testimony that this was actually cannabis sativa L. There's not been any expert testimony on that front. And no witness was presented to do that. So unlike lots of other drugs, which are readily apparent as being unlawful, marijuana has a variety of different offshoots that are and can be legal in the state of Texas. And additionally, the firearm, to be unlawfully carrying a firearm, there has to be proof of the sort of precipitory, excuse me, Judge, offense of some unlawful possession of marijuana. Here again, he is in possession of some kind of green leafy substance. And there was no testimony about what that substance ultimately was. And so absent that, additionally though, Judge, I would argue that the state did not prove the lawfulness of this stop in this case. The Detective Busby testified that his opinion was that this front windshield was too dark. He said he had a monitor, and there's actually a specific requirement that you have 25% light variance in these in the transportation code, and that 25% light variance applies. And he has a tool. I specifically asked him, "You have a tool to measure that?" And he said, "Yes, he did," but he didn't present any evidence that that was actually employed here. And in fact, on the side windows, you could see that he immediately had the windows rolled down. He never checked them again, as far as I'm aware from the video. And he never used the tool to check the front windshield. So just at the very outset, he's making a guess or a hunch that this was, an unlawful window tint, but he didn't actually present any evidence of that other than just his own opinion. And so we object to the stop, we object, and we believe the court, even if the stop were reasonable at its inception, he made no effort to confirm the reasonableness by testing the windshield or the side windows. And then secondarily, again, as we pointed out to the court, there was no evidence of what the content of those bags actually was. Thus, there's no evidence to support him unlawfully carrying a handgun or marijuana. So put that sort of in bucket number one. In bucket number two, Judge, the state has alleged here the offense of manslaughter and the offense of aggravated assault. And I'll start with those two because they require proof by the state. Again, I know it's a lower level of proof at this stage, but they require proof by the state that Mr. Fletcher acted recklessly, that he was aware of but consciously disregarded the risk that this specific result would happen. And speeding obviously is unlawful. He was speeding, certainly, and that's a Class C misdemeanor. He was speeding, but the cause of this accident, and the state's own expert has testified before. And the reason I bring up this other case, Judge, is it is monumentally unfair, in my opinion, that the state, in two cases that are almost identical to each other, take contrary positions when it suits them. In other words, Mr. Coleman wasn't involved in that trial. I'm not attacking Mr. Coleman at all, but it's this district attorney's office has taken the position that, oh no, if you fail to yield the right of way, you're always the cause of the accident. And then in here, they're like, well, no, it's okay if you fail to yield the right of way because he was speeding. Well, you can't have it both ways. And it's exceptionally frustrating because what it appears happens is if someone dies, we figure out a way to make the rule fit for that case. And that appears to be what's happening here. The recklessness falls on the person who didn't die. And that's not how the law is supposed to work. A person is required under the law to yield the right of way, regardless. And I didn't go through the whole soliloquy with Mr. Wright that I did in the previous trial, but I tried to get him 100 different ways to agree with me that failing to yield the right of way was not the cause of an accident because the other person was going too fast. And Officer Wisby said the same thing. She has written lots and lots of tickets for failing to yield the right of way. And everybody always says, well, the other person was speeding. They still get a ticket because they're still the cause of the accident. Here, he was speeding. He was cited for going too fast, I believe. But the actual end result for recklessness purposes is he was not the cause of this accident. The vehicle failing to yield the right of way is the cause of the accident. Mr. Fletcher's speed certainly contributed to it. They wouldn't have been in the same spot at the same time. But as a practical matter, in terms of following the law, the Honda failed to yield the right of way. And that was their requirement, being at that stop sign. And so his recklessness is not the cause of this death in this case. And so for those purposes, and I would say the same thing is true for the negligent homicide as well. Again, you know the difference between the two. I don't need to go through the whole litany with you, but here again, we can have a jury trial about all of these issues and let a jury decide that. But for the purposes of this court's decision here today, there's certainly not evidence that he was recklessly causing the death. And that's what it would have to be. His recklessness needs to cause the death. And that's not what happened here. It's the failure to yield the right of way is what caused the death here. And that's unfortunate for the family and for everyone involved. It's a terrible tragedy for everyone involved. And I'm not trying to belittle that, but we have to be realistic. And the state has to, I would argue, take a consistent position about these cases. And they're not doing that here. And for that reason, we object and we ask the court to either find those things not true or hold them in abeyance and let us have a trial on these issues and let a jury decide with his presumption of innocence, let a jury decide these issues, Judge. Thank you.
So obviously I was inclined to hear this case, the motion first. which is somewhat rare. Typically we'll have trials first and I allow the state to go forward this way. At this point, well, a couple of things. There was no evidence with regard to the testing of the alleged marijuana. I don't know if there was testing, if there would be at some further, there hasn't been. I looked back, just as I said, I took judicial notice of the court's files. So I went back in the motion to revoke case, and there was a motion to revoke that was filed back in 2024, 3, something like that. There was a hearing, it looks like potentially. And at that point, the state, not Mr. Coleman, but the state over in drug court dismissed that motion to revoke based on that motion to revoke had the 2 allegations, the unlawful carrying and the possession of marijuana.
If, I'm sorry to interrupt the court, Judge, but I've got authority case law that says that an officer can prove up or substantiate marijuana based on his or her training experience alone. The smell of marijuana and the odor, and I'm happy to provide that case law to the court.
That would surprise me if that was, now I would love to see it, because then I will take a break to read it. But, you know, I mean, it's pretty specific now that there are different types and different levels, and some are legal and some are not legal. And as far as I know, there's nothing that can be trained by smell or look as to whether or not that marijuana is legal or illegal.
If I may add, Judge, the defendant himself said it was.
I understand, but as in any, look, here's the thing. Do I think it was marijuana? Yes, I think it was marijuana. I think Mr. Fletcher was probably dealing marijuana. That's my opinion. I am constrained by the legal definitions of marijuana and what the testing shows on all drugs. He can think he has cocaine and it turns out to be baking soda, and he would not be guilty of possession of cocaine, even if he thought it was. That's my understanding of the drug laws. And I think that's the problem, and probably why back then there was a dismissal of that motion to revoke filed in drug court that specifically stated, let me find it. It was checked off, you know, why it's dismissed. And that was back on October 16th of 2023. And the mark that was checked off was the evidence is insufficient. So I don't know if there wasn't testing done on the marijuana. I think the testing is required, even as a preponderance. I have notes here. He admitted it was weed. The officer believes it was weed. It clearly was probably weed. Probably weed doesn't get me where I need to be. So I'm saying this for everyone because it's very frustrating for me, because I do believe probably that it was marijuana and that it was illegal, and that Mr. Fletcher was selling it, distributing it, and I mean, you don't have scales and you don't have baggies, and you don't have all those things, and you don't have a firearm. But for purposes of this hearing, I don't believe I can find that count true based on the evidence presented today. So unfortunately, I am going to find counts 4 and 5 not true based on that today. Now, with regard to counts 1, 2, and 3, obviously this is somewhat a I don't know, I don't want to call it a battle of the experts or whatever. I don't see how the speed that Mr. Fletcher was going did not have obviously some cause and causation in this wreck. Also, there was no testimony that said all the testimony that we heard today was that there was in fact a failure to yield, which is extremely unfortunate. And I think What I am inclined to do, and what I was probably already inclined to do before Mr. Gertz mentioned it, is hold off on making a finding in counts 1, 2, or 3. I think all of that probably needs more hashing out, more evidence than what a short hearing would give. Obviously, a jury or even me, if it were a full-on bench trial where it was beyond a reasonable doubt. I'm not inclined to make that decision based on a preponderance of the evidence because of the conflicting evidence and things like that. So what I intend to do is I'm going to hold this motion in abeyance. We do not have a current trial setting, but I will get one very quickly. The case will be tried, a jury will determine whether or not Mr. Fletcher did in fact commit the offense of manslaughter, the lesser offense of criminally negligent homicide, and or the aggravated assault with a deadly weapon. I think that's probably the better and more fair way to do it for everyone. I don't want anybody to feel like they wasted their time today. But based on the evidence that I heard today, which I would not have known had we not had this hearing, kind of wouldn't have known how to go proceed. So I would say we know that now. I'm going to hold the matter in abeyance. I am not going to make a finding on counts 1, 2, or 3. I'm going to hold making any finding. And then we will see what happens with that trial. That's not to say either that after a trial, even if a jury finds Mr. Fletcher not guilty of those offenses, that with further information that I believe I could legally take into consideration at a trial, I could still find these matters true, some, all, or none of them, after that hearing, based on the evidence I've heard today and the additional evidence that I'll hear at trial. So the motion's not gone. There's still that possibility. But I think legally and in all fairness to everyone, that's the proper way to handle this matter. I will get with Ms. Holmes today. Again, we will get a trial date extremely quickly as we possibly can. I know everyone is suffering and needs some closure to this. I apologize that you're not getting closure today. You likely would not have anyway, because the cases, no matter what I would have done today, are still going to go to trial. So let's get that part taken care of, and then I will conclude the motion to revoke matter at the conclusion of the trials in the other cases. All right. All right. I do want to thank everybody for being here. I know this is extremely difficult, and sorry for what everyone's going through and for your losses and all of that. Mr. Coleman, did you have something else?
Move to withdraw the exhibits, Your Honor, so that they maybe use the trial.
Yes, sir. I will allow you to withdraw all of those exhibits. And again, we'll get a trial set as quickly as we possibly can. I'll look at some weeks, maybe even when we don't already have trials, so that it could be specially set if necessary. I know there'll be several witnesses. And so I'll let you guys know as soon as we have that set.